My name is Paul Siskind. I have a background in biology and music and also legal advocacy and political lobbying. And my talk today is about workplace bullying and mobbing, really about the legal basics and the legislative challenges. They're going to pull up my presentation, so this is just a quick start. My impetus for giving this talk was when I attended this conference last year, I noticed that there really was a lack of baseline understanding of the legal loopholes that occur, that allow workplace bullying and mobbing to happen. And so I really thought it would be worthwhile to give this organization a cursory overview. Now, this is very cursory. It's an oversimplification with broad generalities, and I know that we have legal scholars, we have practicing lawyers, we have a number of administrative judges here, and so please understand that these are oversimplifications. And as was mentioned earlier by Giselle, that different jurisdictions have different laws, and it's very hard to talk about these issues as a whole, given the jurisdictional differences. I'm not a lawyer, and I'm not playing one on TV, and I'm definitely not giving legal advice, but I have done a lot of work in working with the New York State Legislature in trying to craft an anti-bullying and mobbing law. So, one detail about just terminology. In New York State law, there's a difference between employment law, which deals with individual employees, and labor law, which initially applied to collective bargaining and unions. But what's interesting is over the 100 years or so that labor law has been codified, there's actually laws in labor law that apply to individual employees as well. So there is a historical distinction, but there's also the way that it's codified in New York law. So I'd like to start with the United Nations Universal Declaration of Human Rights, which states everyone has the right to work, to free choice of employment, to just and favorable conditions of work, and to protection against unemployment. However, as a UN declaration, it's not legally binding, and there are no mechanisms for enforcement. And I'm going to double underline that word enforcement, because that's really the crux of the issue about all of these legal issues. More importantly, even though the U.S. is a signatory, the U.S. Constitution doesn't give its citizens the constitutional right to have a job. And there is no no state in the U.S. that guarantees its citizens a right to work. Now, this is confusing because a number of states have what are called right to work laws. But this title, this name is very misleading, and I happen to think intentionally. In the US, a right to work law doesn't mean that every person has a right to have a job. It has a much narrower definition. It prohibits all companies and all unions in that state from requiring employees to join a union and or requiring that employees must pay union dues even if they're covered by the union contract. So that's basic confusion number one, that right to work actually doesn't mean right to work. More important, there's a fundamental concept that underlies all of employment law in the United States. Because there is no right to work, and because the economic system favors free market capitalism, the default is that employment and labor laws generally favor the employer rather than the employee, unless a specific right or law creates a specific protection for the employee. And this is encapsulated in the concept of at-will employment. At-will employment isn't a law, it's a doctrine. And you'll see that I use definitions mostly from the Cornell University Law School WEX. And if you would like my slides, you can follow all the links to the definitions. So the definition of at-will employment is a doctrine that an employer and an employee agree there is no set period of employment. Additionally, the employment may be terminated by either the employee or the employer at any time and for almost any reason. Employment at will is considered the default standard. In the United States, 49 states follow at-will employment doctrine. Montana is the only state that requires just cause for termination, but that's after a 6-month probationary period where at-will employment holds sway. When you look at these, if you decide to follow the links, a little bit of terminology. Many of the statutes use the word discharge rather than termination. So that's the legal term for being fired, termination, discharge. And there's also a concept, and this came up in the previous session, constructive discharge means when the employer creates an onerous work condition that basically forces the employee to retire. The legal term for that is called constructive discharge. There are some exceptions to at-will employment. First of all, public sector employees are generally covered by civil service laws and/or unions. And in some employment contexts, there are explicit contracts, either with an individual employee and/or union, and Peter Wiley and his session next, later this afternoon, will be talking about union issues. The employment at will doctrine does not predict termination for all reasons. There are wrongful termination exceptions, and these vary state to state. The biggest one is known as the public policy exception. If there's a public policy that bars an employer from terminating an employee because of a well-established public policy, then that's considered a wrongful discharge. For example, if you file a workers' comp claim and your employer fires you because of that, that's considered a wrongful termination because they have a duty to allow you to file a workers' comp claim. Okay. Each state has different laws allowing different exceptions and what qualifies as wrongful termination. So some of the common ones are refusing to commit an illegal act on demand of your employer. So if your employer wants you to commit fraud and you refuse to do so, you can't be fired for that. Or if you have a statutory right, such as filing for workers' comp or for union activity, for requesting family medical leave, etc. Or for fulfilling a public duty, such as jury duty or serving in the National Guard. Whistleblowing is generally covered as a public policy exception. And what's interesting is this particular website left off wrongful termination due to discrimination and retaliation. They're not officially under the public policy exception, but those are wrongful terminations. What's interesting, and what matters probably the most, is that another exception to at-will employment is implied contract and/or implied covenant of good faith. An implied contract exception means that an employee has a reasonable expectation to a fixed term or indefinite employment based on the employer's actions, and therefore the employment is no longer at will. Such actions may include the employer's statements and employer's standard practices, like only firing for just cause, or an assertion in the employee handbook. Okay? And the covenant of good faith is similar. What's interesting is the United States has a patchwork of laws, and you can look at this more closely following the links. Some states accept the implied contract exception, and some states don't. Other states have the implied covenant of good faith, and some states don't. So again, a lot of this depends on jurisdiction. Now, there's a side issue, and I'm mentioning this because many of the attendees of this conference are academics. And that question is, but what about tenure? Does tenure protect against at-will employment? And on paper, the answer is yes, but in reality, it is not really. Tenure protects, quote, academic freedom by giving employees two rights that aren't granted under at-will employment. Number one, termination for just cause, and number two, due process, which is sometimes termed a fair hearing to determine if just cause exists. However, even though tenure and states that accept tenure as a doctrine says you can only be fired for just cause, in real life situations, employers can come up with very flimsy reasons and even lies that justify their just cause. And so it's very easy for them to just make up a reason because there is no accountability outside of the school itself, unless you work for a union school and then you have a grievance process, or if you work in a state that allows for litigation under the good covenant or the implied contract exception. Now, there's a lot of misunderstanding about due process because on paper it looks great, but in actuality, due process only means that the school and or the union has a procedure and that they follow it. It doesn't mean that the procedure itself has to be fair, and it doesn't mean that the outcome has to be fair. It just means they have a procedure and they followed it. It doesn't have to be a fair procedure. So this topic can be an entire presentation on its own. While I won't delve into it, I do have a link there. I think this is the clearest, most succinct article I found that explains the loopholes in the tenure system. So I would highly recommend reading that. Just want to make sure I'm staying on time. Okay, so the crux of the matter. There are two legal loopholes that allow bullying and mobbing to occur. And these are loopholes in employment law and labor law. Number one, the definition of harassment and the definition of abusive hostile work environment. And number two, the fact that employers' policies don't necessarily create a two-way contract. So loophole number one, definition of harassment. For simplicity of this talk, this overview, we won't pick apart the minutiae of the definition of abusive conduct and behaviors. This is actually part of the challenge that we have in trying to craft a law. The main point is there is no law at the federal level and at most state levels that generally prohibits abusive conduct in human interactions. Most laws have only specific situations defined. Criminal harassment, which is usually in a state law included in their stalking law, which in order for something to count as criminal harassment, there must be the intention of causing bodily harm, and in some states, or causing some substantial emotional distress. Then there are other examples of harassment which are covered by telecommunications, such as texts and emails, cyber stalking, and a really strange one in New York state law, debt collection. It must have been a thing about harassment in debt collection because that's a section of New York state law. In employment contexts, discriminatory harassment creates an abusive, hostile work environment. And then similar laws in access to education. Here's the kicker. Harassment is only illegal if it either, one, creates a reasonable fear of physical injury, psychological injury itself doesn't count as harassment unless it's connected with stalking. Or number two, the harassment is discriminatory in nature, which means the harassment is abusive conduct perpetrated because of the victim's gender, race, age, religion. Bullying and mobbing is non-discriminatory harassment, which is why it is perfectly illegal. Which is why it's perfectly legal. I'll give you my story. I had a colleague who would harass me in the hallway and just say, "Fuck you, Paul," and walk away. My union rep my dean, my HR person, the SUNY lawyer, and my own lawyer all said, he's allowed to say, fuck you, Paul. That's non-discriminatory harassment. If he said, fuck you, Jew boy, or fuck you, faggot, then we can do something. But by saying, fuck you, Paul, we can't do anything because that doesn't count as harassment. That's literally how blatant that issue is contained in the law. Some people call it, I like to use the term non-discriminatory harassment. My colleague Mike Schlicht, who you'll meet later, tends to use the term status-blind harassment. They're in many ways interchangeable. The upshot is, when we are talking about bullying and mobbing, we have to be careful not to use the words hostile work environment, abusive work environment, because at least in New York State, those terms only have legal meaning if they have the discriminatory intent. And so our arguments as academics and in court, in legal situation, can be totally dismissed if we're using the wrong word. SUNY literally said to me, I wrote to SUNY and said, I want the harassment to stop. SUNY responded, you asked us to protect you from harassment. You were not being harassed, you were being bullied. Because you asked us for protection from something that wasn't happening to you, we had no obligation to stop the harassment because it wasn't happening to you. That literally was said to me. Okay? Next. Psychological injury. This is an aspect which is possibly an opening for creation of law. There are two laws that are in tort law that do address psychological injury. However, they have very, very high bars. The conduct must be extreme and outrageous, and you can read the definition there, and the severe emotional distress must show that they experienced distress that was so severe that no reasonable person should have to endure it. That bar is actually very, very high from a legal perspective and almost unattainable in most cases. These two laws fall under what's known as intentional infliction of emotional distress and negligent infliction of emotional distress, which in some aspects is now being renamed as duty of care. The other loophole is, even if an employer has a written policy that explicitly says we won't allow for mobbing or bullying, in most employment situations, depending on the state where you live, an employer is allowed to ignore their own policies whenever they want to, even if it is written in an employee handbook. Why? Because of at-will employment, it doesn't require that that handbook policy be a two-way contract. It's a one-way contract. The employee is bound to follow the policy. If you don't follow the policy, you can be dismissed, but the employer can ignore it whenever they want, unless they ignore it in a discriminatory manner. If they only uphold it against women, if they only uphold it against LGBT people, then that's discriminatory. But they can choose to ignore it whenever they want. That's a very, very big loophole in the law. Those two loopholes together are what allow bullying and mobbing to occur. Those two loopholes underlie almost all of the discussion that we're having here today. Because without those two loopholes, all of these ideas that we have about policies, etc., are meaningless until we plug those two loopholes. Okay. Now, this conference has been talking about systemic and cultural loopholes. I've really learned by looking at law from the inside out that policies and laws only matter if they're enforced fairly and effectively. Yep. We live in an era in the United States where everyone basically has the attitude, I'm not going to do the right thing unless you force me to do the right thing. So the question is, how are we going to force people to do the right thing? And we're seeing that with litigation lawfare under the Trump administration. And again, prime example of this in academia, even though academia has all these policies about tenure, unless there is accountability outside of the system and an enforcement mechanism, it's only word on paper. It works when it works, but when it doesn't work, it doesn't work. And there's nothing you can do about it. So what can we do? We can change the culture and the norms, expectations of behavior. We can encourage and we can require employees to have a policy. But again, unless you have a way to enforce the employer to uphold their own policy, a policy is meaningless. Same thing can encourage policies in union contracts. There is a little bit of outside accountability in unions because of the grievance procedure, but it's actually kind of complex and weak. Or we can create federal, state, and local laws. And we will be having a roundtable discussion this afternoon about this. Thank you.